Good evening. This is the Thursday, September 5th, 2024 Planning Commission meeting. I'll call the meeting to order. Next up, I'll entertain a motion for the approval of the agenda.
How about a roll call?
Oh, yeah, we always got to do the roll call, don't we?
Ready?
All right, Megan?
Megan.
Megan. If you
Clark
call
Gruber.
the roll.
Of course. Clark Gruber.
Here.
Eddie Polk.
Here.
Michael Neese. Oh, I'm sorry. I have the old list. I apologize. I'll just look up at you. Amy Nichols. Here. Bob Sherman.
Present.
Mike Campbell.
Here.
Mary Hosley. Here. Janice Varney. Larry Heinig.
Here.
And Tim Stegman.
Here.
Perfect.
All right, next up, we'll approve of the agenda.
Mr. Chairman, I move to approve the agenda as printed.
Support.
It's been moved and supported. Is there any other discussion? Seeing none, all in favor, please say aye.
Aye.
All opposed, motion carries. Next up, item 3, meeting minutes, August 8th, regular meeting, and also a workshop. You can take them individually or as a whole.
I would move to approve the August 8th, 2024 regular meeting with an amendment. And I had shared it ahead of time with everybody after the statement, Nichols, under the regular agenda part, Nichols said that she would appreciate a heads up for this type of amendment. Insert, Hosley explained she had looked at the minutes only the day of the PC meeting and stated times on the video for review. And that also in between bluff and the period for the sentence that says Hosley voiced concerns about protecting the bluff, insert comma, including the fact that the property immediately to the south is the high-risk erosion area, and from the photos Hosley sent for distribution before the Planning Commission, a significant drop-off exists where the hot tub is proposed to go. And there was a typo after Hubbard in the first paragraph of Agenda 6.
Support.
Okay,
Support.
it's been moved and supported. Is there any discussion? Seeing none, all in favor, say aye.
Aye.
All opposed? Okay, that passes.
And I would move to approve the minutes of the August 8th, 2024 workshop as presented.
Second.
It's been moved and supported. Any other discussion? Seeing none, all in favor, please say aye.
Aye.
Opposed? Next up, we'll have public comment. Citizens in the audience may address the Planning Commission regarding items on the agenda for which there is no scheduled public hearing. Name, address, and you have 5 minutes.
Rachel Sankovsky, 251 Hubbard Street. I came before you last meeting and attended not this week's Planning Commission meeting, but the prior one. And then I sent an email to all of you as well, and that went to City Council and to Callie Doucette. And I'm hoping that you all had an opportunity to review that email. I did go into Kelly's spam apparently, so it wasn't forwarded until this week. Tonight, just really kind of one thing I guess I want to address, and that is I'm not understanding why the site plan submittal requirements for 249 Hubbard Street and the driveway that we've been discussing the last few weeks, why those submittal requirements were waived. The use of that driveway is integral to the site plan. And so I am seeking some answers to that, and I'm also seeking maybe some education because I may just be reading the the incorrect part of the ordinance, or I may be interpreting that incorrectly. But of the zoning ordinance, I'm on page 79, and there is probably a lot of language that I don't understand. But point 3 does say that the zoning administrator or planning commission, when requested by the zoning administrator, may waive site plan review and action thereon. And then there are circumstances where that may apply. And I did speak with Kelly yesterday about the site plan, and she said it had been waived, and I neglected to kind of follow through on that and understand why it had been waived. Now, point C under that part of the ordinance, and point C is on page 80, says all such waivers are recorded by the zoning administrator in a log along with the rationale for the waiver. So there has to be some rationale that exists somewhere in the documentation. So I am requesting that and request this to be on file, that I am requesting that to understand further why it has been waived. All I am trying to do as a citizen and as a property that is impacted by your decision is to understand what is going to be constructed on that site. Now, early on in my first interaction with Mr. Pierce, along with my husband, we got the opportunity, with his great excitement, to see the plan for that property. And that property was, at that point, the plan was, with a beautiful drawing, a barn-dominium. Now, I think you're aware of what a barn-dominium is, and if you're not, I would suggest that you go down Baseline and you have a look at the barn-dominiums in the country, which are large pole barn type of structures that house vehicles like RVs, and people live in them as well. And interestingly, when I looked at the staff report, on page 62 of the staff of the Planning Commission agenda packet for July 11th, on page 62, it says that the proposed use is expected to be harmonious with the character of adjacent properties. Well, I am here to suggest that a barn-dominium is not harmonious with that established neighbourhood. And I know you might think that that's a moot point because we're discussing a driveway, but approval of the easement to begin construction on that site allows the opportunity at this point for anything to be developed there. And so the drawing that you have in your packet is a remedial drawing done by I don't know who, but the site plan specification requires that you actually submit an architectural or a professional plan, and that has not been done. So to this point, we're really not aware of what type of construction is going to take place on that piece of property.
Okay, thank you.
Thank you.
Anyone else?
Good evening. Kathy Campbell, 825 Phoenix, same item. And my approach is a little different. I want to thank you for revisiting the item. I wish, a lot of the details were available to us prior to your decision. We got them after the fact, and I think that what's happening tonight is a blessing of your previous approval. But my favorite items that we received, the setbacks. 45 feet north from the north side of the driveway will be where the home begins. 17 and a half feet from the west side, 10 and a half feet from the right. Acknowledgement of a two-story home to be used only for residential, no business. The previous submission gave us an illustration of a home with 3 traditional garage bays which gave me peace of mind. Same thing that Rachel mentioned, no big barn for any reason. And I also appreciate the dust control that was, I believe, put into the motion for approval. And since we don't have a shared driveway agreement, I'm going to trust that the responsibility for dust control for construction and beyond resides with the applicant for the special use. So, looks like the house will be beautiful, tucked back in the woods. Thanks for bringing it back. Thank you.
Anyone else?
Dwight Pierce, the owner of 249 Hubbard. I was surprised to find out my permit was coming before the Planning Commission again, and I don't know what the issue is, and I don't know if I will get to speak again, so I'm going to make remarks that may or may not be pertinent to what you're doing. I may offend my neighbors that have come to speak or have spoken, and some of you on the Planning Commission by what I'm going to say. It is not my intent to be disrespectful, but to voice my opinions and protect my rights regarding my property at 249 Hubbard. Start with, this whole process is backwards. The special use permit should have been given to use the driveway before the lots were allowed to be combined. This would have given the neighbors notice of what is going on and can voice their opinion. Once the permit is issued, then the lots can be combined and sold with no repercussions to the new owner. The way you do it now makes me the bad guy for doing what I'm allowed to do. The city has already approved that this is a building lot. The city has already approved that 249 has an easement for access and utilities. The only reason we're at the Planning Commission is that technically that your board has to approve the joint use of the driveway. The city building department controls what I can build through their codes and ordinances. I don't see how it's even legally possible that you cannot approve the permit given the city has already approved everything. This brings me up to my neighbors that came and spoke at your last two meetings. My wife and I were very hurt, disappointed, and angry at their attempts to keep us from building on 249 and trying to control the use of the driveway. No one tells them how they can use their driveways. If they have 2 or 6 cars in their driveway, that's their business. If they have a family get-together and there's a bunch of cars for the weekend, that's their business. If my neighbors are so concerned about another house being built and the use of the driveway, they should have bought the lot and 253 themselves. 253 has sold twice in the past 2.5 years. Once 249 went for sale, they all knew a home would be built there. They all knew the new owners would be using the driveway. They all knew people would be walking and driving down the driveway. I get it that they would rather have the open space. Who wouldn't? But since they did not buy the property, they have no right to try and control the driveway or a home being built. They forfeited their right to have any say in how the driveway is used. It's not their business. The control is Flax at 253. They own the driveway. I just get to use it. I want to let you know what was missing or misleading on the remarks to use the driveway. This driveway has always been used by 2 residences since 1970. The front portion of the driveway was originally the driveway of 251, Rachel's house. Since the early 1900s, when 253 was built in 1970, the driveway, my lot, and 251 was owned by Shambos, and they linked the driveway to their new home. Rachel and her husband bought their home in the mid-1990s from Shambos at 253. 251 and 253 used the same driveway for a long time, 40-plus years. Only in recent times has 251 not used the driveway. There was never a written easement, and 251 was denied use of the driveway approximately 10 years ago, and they built their own stone driveway. I learned this from a relative of Shambos, the past owners of 253. The argument that the driveway is unsafe and not meant for more traffic is not true. It was used this way for 40-plus years with no issues. There were comments that the driveway is too close to 255. 255 purchased her house with the driveway there and both residences using the driveway. 251 cannot even see the driveway from her house. There are bushes and a fence blocking any view of it. The driveway is simple, none of their business. The only comment that was their business was not changing the grade to allow runoff towards their home. There were comments made to pave the driveway and have an owner's maintenance agreement made by the resident on Phoenix, Jackson's. I didn't understand that why that resident's concerned over the driveway. They have no use of the driveway and it's at least 150 feet from their house. I and the owner at 253 the Flacks have no interest in paving the driveway. Part of the feels the country looks so close to town. It's been this way for 55 years without an issue. There was a comment that people use the drive to cut into the backyard of Jackson's to access their neighbors' backyards. They planted trees and put in posts along property line right after I bought the lot. That is a police issue of trespassing and vandalism if that happens, and not a planning commission issue. At the last meeting, there were attempts to put up to 8 amendments under the permit. I understand your attempts to try and please the neighbors by your amendments, but I don't feel you can cherry pick what you're doing. Amendments need to be done through codes and ordinances so everyone is treated the same. If I have to do dust control, every new home being built has to do dust control. Every new home has to have the wording of all fees and escrows must be paid before starting. Every house being built will have its garage scrutinized and the siding being used scrutinized. Where does it stop? I was told by the building department that as long as I build according to city codes and ordinances, I could build pretty much whatever I want. We are in fact building a cottage house, pretty much 1-story, 3-car garage. Whether I have a large garage or what siding I use is my decision. The city wants to control how a house fits in the neighborhood. They didn't do that through ordinances. The garage size was questioned. Most new houses have 3-car garages now. And I want a workshop to do woodworking to fix things. That's my business and not the neighbors, and frankly, not the planning commission.
Okay, thank you.
Thank you.
Anyone else? Going once, twice, third time? Okay. And then I will mention our planning commission comment log of emails we received. We have emails on the August 14th from Kathy Campbell and Elaine Herbert regarding 249 Hubbard Special Land Use. Rachel Siankowski, August 20th, 249 Hubbard Special Land Use. Elaine Herbert on 23rd of August, PSTR Rental Terms and Enforcement. Lisa Croupiers, August 24th, Permanent versus Non-Permanent Signs. And again on the 27th regarding new zoning ordinance lot coverage calculation. So that's 6. I think I have them all. Am I missing any? Okay. So ends the public comment period. Next, we'll move to unfinished business. Item 5, 249 Hubbard Street, Special Land Use Approval Resolution.
Mr. Chairman, if I may, I would just introduce 249 and 906, 249 Hubbard and 906 Monroe together.
Okay.
And then any discussion and action that you may wish to take could be taken separately on each item. So last month, the Planning Commission reviewed and approved 2 special land uses, 249 Hubbard Street and 906 Monroe Boulevard. One was for the shared use driveway, as we've already heard a little bit about. The other was for an in-ground hot tub. Following these approvals, some procedural questions were raised primarily by Councilmember Hasley about these approvals. And in order to ensure a clear record and compliance with both the Michigan Zoning Enabling Act as well as our own zoning ordinance, staff has worked with the city's attorney to prepare resolutions for your consideration tonight. These resolutions would essentially amend the initial approvals and provide clarification regarding the basis for approval and the conditions associated with each approval. So the reasoning behind each resolution is similar to provide clarification and compliance with the procedural questions regarding the approvals.
Okay. And who wrote the resolutions?
I worked with Bloom Sluggett.
Okay. Would you like to walk us through the resolutions?
Mr. Chairman, good evening, members of the Planning Commission. I'm Cliff Bloom from the City Attorney's Office. As Kelly mentioned, there's some procedural issues involved, and one of the things that Michigan law requires when you make a special land use decision is that you go through the standards to make sure they're met, which I'm sure you're all well aware of. but it's also got to be documented in writing, and the easiest way of doing that is a resolution. So essentially, we provided resolutions in both the 249 Hubbard Street case and 906 Monroe Boulevard. And it would adopt findings, and it would incorporate staff's memorandum regarding the same. So we think this is the correct procedural way of correcting what was probably a technical error. And going forward, I think this process will also be utilized in similar cases. Thank you.
Okay. All right, any questions for Kelly or the city attorney?
Mr. Chairman,
Yes.
so I noticed that the two conditions that were approved in the last motion were removed from this particular resolution, correct?
That's right, they were.
Okay. So is it appropriate for us to discuss restoring those to the resolution by citing a standard for the special land use along with a justification that goes along with that standard?
I don't understand the question. Say
Well,
that one more
Let
time,
me say it
please.
in a different way. Are we allowed to restore either or both of those conditions if we were to cite the standard to which they apply and provide a justification that the Planning Commission would adopt as a finding?
So I think the reason for the removal of the condition related to the location of the driveway is primarily that the parcel is owned by 253 Hubbard. And after speaking with David Everly from Attorney Bloom's office, there were some concerns that that condition was not enforceable.
Okay.
So if there are other conditions, I think that's appropriate. The resolution can be amended, language can be stricken, language can be inserted, but we need to be quite careful about the way that we handle that.
So I'm fine about the moving the driveway. What about the dust control?
I think that dust control is less of a concern. So if dust control is a condition that the Planning Commission would like to add back in, I'll defer to our attorney who is here, but from my standpoint, the dust control was less of a concern than moving the location of the driveway.
Mr. Chairman, can I respond? I'm going to say something which is part of the reason that the public doesn't like attorneys. When you look at this process, what you're really doing under this proposal is not to go back and change anything substantive, because there's no mechanism that we're aware of, either in the ordinance or at law, to reconsider the substance, the approval, or anything substantive. With regard to the condition that's pretty clearly illegal, that can probably be taken out. Theoretically, the dust control, if it was part of the original motion, should probably stay in, because again, there's no mechanism for reopening substantive things, with three exceptions. The law says if there was fraud or false information provided, there's no indication of that. If there's substantially changed conditions or newly discovered evidence. And probably none of those are applicable, so you probably can't substantively change things. This is just to go back and procedurally make sure that the decision complies with the ordinance. And it was correct. It didn't have the findings that should be redone. So I think technically the dust control should stay in. If the commission is convinced, based on Dave's legal opinion, that the one is unenforceable, I think that could be stricken.
Understood.
All right.
Yeah. Okay, go ahead.
So I'm going to amend, or I'm going to propose the amendment to the resolution, but I also would like to ask another question.
Yeah, this is question round, so no
Right.
motions yet.
Yes. So the other question, which I think you were out of the room when one of the speakers was here, was you had waived the site plan. And I believe that the speaker was looking for a rationale for that, given that that's apparently required by statute that she cited. And so I was wondering if you could cite the reason for the waiver in this particular case?
Sure. For this type of application, as with others like it, it's not been our practice to require an engineered site plan. In this case, the conditions are existing, the use is existing, no changes were proposed to the site. And we handled this similarly to special land uses for daycare, a group daycare home, and other applications like that. So if the planning commission as a group were to have felt that the plan information, the application information submitted by the applicant was inadequate, then it would be your right to seek additional information from the applicant and consider that at a later date. That did not happen at our last meeting.
Done with my questions.
Okay, who's next? Mary?
No one else. Attorney Bloom, so how, can you cite to any municipality where a resolution has been used like this, where it's on the record and published?
Are you talking about a corrective resolution, or are you talking about resolutions in general?
No,
with
corrective
findings?
resolutions like we are
I've been
addressing
doing this for
today.
41 years and sat through many of these. I'm not aware of the issue ever coming up that I've been involved in. What we did is we analogized it to an appeal of a zoning board of appeals decision or planning commission decision to the circuit court. If the circuit court believes that the record's not complete or the findings weren't made, what the circuit court normally does is remands it back to the body, not to open it substantively again and so on, but to make the proper findings and so on. So that's the closest analogy we could get. I've never seen a zoning ordinance that deals with this because it's relatively rare. I'm not aware of any appellate decision. I'm not going to say there isn't one out there, but so it's, admittedly, we're analogizing to several different situations.
So you're not aware of this situation occurring
And I
before?
hope I never encounter it again before I retire.
Also, you had talked about ways to reopen it, and what if there is a misunderstanding of what should or should not have been considered relevant?
With respect, I don't think that probably rises to the level. Generally, the three things are fraud or false information, which is not an issue here, substantially changed conditions, and newly discovered evidence. So I think that would be a really hard thing for courts to look on because we're all human. I served on a planning commission. I'm sure I made a lot of mistakes and so on. So I don't think that probably rises to the level. It is good that you brought this up because going forward, it's going to be important to do these resolutions and make the findings.
Or we could just do the findings on the record. But now, in a situation, as Commissioner Campbell spoke about with the dust control, one issue that I had attempted to bring up is the fact that, it's a two-track, for lack of a better description, dirt driveway. And, there was even a comment by Commissioner Sherman about the existing home, the existing home is a short-term rental, and that is that's driving the traffic, and a new home to be built is a second home. In South Haven, I think history shows that people represent homes as being a second home, and then they're a short-term rental. And currently, there could be a personal short-term rental, and we all appreciate that increases the traffic. And our ordinance specifically indicates that for a special land use, that, it should not be allowed if the uses, activities, processes, materials, or equipment which will be detrimental health, safety, and welfare of person or property through the excessive production of traffic, noise, water runoff, or other nuisances. So increased traffic from a short-term rental could easily affect that. Home occupation, which has traffic, could easily confirm that. And attempts to discuss that were dismissed at the previous meeting because we were looking only at the use. So possibly I just didn't word it properly, but it would seem that a rational condition under those standards would be that, that there would be no additional STR or commercial business home occupation of the two-track driveway, so that it would be limited to the driveway. Can you comment on that?
Again, I think that's a substantive matter that could have been brought up before, or was brought up before, and the majority didn't add it. So I don't think you can reopen that during these proceedings.
But if the majority thought that we could not look at the use of the driveway based on construction,
Again, I think a mistake in belief does not rise to the level of what a court would allow it to be reconsidered or reopened, because that would lead to many, many special land uses being challenged and reopened, and there's the need for certainty. I'm not saying your condition is not reasonable, but I think probably that ship has sailed, and if you reopen it for one thing, then you're probably going to reopen it for other substantive matters.
as long as the statute of limitations haven't run, but I appreciate that aspect of it. Oh, no other questions.
Okay. Anyone else? No? Is there a motion?
I make a motion to adopt a resolution approving of the special land use request for 249 Hubbard Street shared driveway.
Support.
It's been moved and supported. Any other discussion or amendments? And I'll just say this, if you're gonna make an amendment, it'd be an imposed condition, and where would that be placed in this resolution?
Can I respond, Mr. Chairman?
Yes.
In the resolution you've got in front of you, you probably could put it anywhere you want before number 7 on page 2. Or for ease, you might say 5A, section 5A in there, and it would be the exact same language that was in the motion earlier.
Okay, because that was substantive from the last motion. And then my second question is just, when, a lot of times it's required that the drives be paved for homes in town. When would a situation like this, when could you say, well, you just need to pave the driveway?
So the planning commission discussed that and did not impose
Right.
that as a condition.
But it could have,
Could have.
yeah. So the dust control is the lesser of the expenses, yes. Okay. So we have a motion, it's been supported. Anything else?
Yes, I'd like to amend the resolution or the motion by adding 5A. And to begin, before the amendment, I'd like to say that Special Land Use Standard 3.
No, I need your motion.
You need the motion first? Okay. The motion would be to amend by adding 5A to require the owners of 249 and/or 253 to provide dust control during construction.
Okay,
Support.
it's been moved and supported. Is there any discussion?
The reason that I made this amendment is that Special Land Use Standard 3 reads, the special land use shall not be hazardous to the adjacent property, property values, or involve uses, activities, processes, materials, or equipment which will be detrimental to the health, safety, or welfare of persons or property through the excessive production of traffic, noise, smoke, fumes, ground vibration, water runoff, odors, light, glare, or another nuisance. I would say that dust is another nuisance during construction, and I believe that we have a situation where a very narrow strip of land is running adjacent to several properties, namely 251 and 255 at least, and given that it's a dirt surface during construction, it seems to be a reasonable condition that dust control be provided.
Okay. Any other discussion?
Since 253 is on record as the owner of the driveway, I believe, right? To propose that as 249 and/or 253, is that a little bit of a stretch, or should we just say 253 has that responsibility?
I'm fine with or.
May I suggest we get legal counsel guidance?
So I was not at that meeting. Were both applicants in this or just the one?
So, to,
Just the one,
So I think you can only bind the
the
one.
one
Yeah,
at 249.
So then we'll amend it to just 249. Hubbard.
And I think he indicated he was willing to do that, or they were willing to have it as a shared responsibility. At least that's my memory of the testimony then.
do we need a support for the revised amendment?
Larry, did you want to say something?
Yeah, I do. The issue before us is the use of a driveway by two property owners. I don't see any construction in that whatsoever. So I don't see where it's appropriate to have anything involved in this resolution that involves dust control.
Yeah, and that was what you had said last meeting, but it is something that was in the prior motion,
Yeah, it was.
so,
I think I voted no on it last time,
yes.
and I will again.
Okay, so there's a slight adjustment. We're gonna strike or what?
253.
253. Without going through all the motion jargon. Okay, you still support?
Yes.
Okay. Any other discussion then? No?
So, I mean, discussion before we vote.
Yeah.
Yeah,
On
I-
the amendment only.
Okay, nope. Sorry, thank you.
So all in favor of the amendment?
Aye.
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 All opposed?
No.
Okay. So the amendment carries. So we have an amended motion. Any further discussion?
I appreciate the effort to resolve the situation from the August 8th meeting. I still am concerned that the intent has not been met for a special land use. A special land use is not a given right. You have specific standards that have to be met, and I had raised concerns about that with regard to the increased use, depending on what went on the property, and I believe that was the intent with regard to sub C, and that and that has not been resolved by the resolution. I appreciate legal counsel's explanation as to why. My concern is that there were misunderstandings on what should or should not be included, and that does result potentially for a more intense use than what is intended with a shared driveway in a residential neighborhood by people living there full-time. And so I still, based on my understanding, as I did at the last time, do not believe all the standards have been met. And although the resolution corrects some of the issues with regard to the facts on the record, it does not resolve the issues that I raised and the purpose for which I had voted no initially, because I do not believe all the standards are met.
Okay, anyone else? No? All right, so we have a motion that's been amended, and we're ready to take a vote?
For the record, Mr. Chairman, do I remember reading that since this was approved previously, it needs a 2/3 majority for approval now?
Believe
question.
that to be the case.
Only if it's in your ordinance.
Perhaps I misunderstood.
To rescind that required.
Well, let's double check.
Let's double check.
Because there are a few things that require 2/3, but I don't remember that being one of them.
It would likely be in the special land use section.
I'm there now.
Mr. Bloom, I think it was even in your email perhaps, because you had said that the previous approval was 8-1, so you didn't anticipate securing a 2/3 majority vote would be a problem.
That was my associate. And
Oh,
I actually
okay.
read that this afternoon.
Well,
but
you attorneys look alike to me,
Thank
excuse
you.
me.
We sound alike, too.
Junior
I'm looking
associate.
through real quickly, and I actually did read that this afternoon.
I'm not seeing anything in our ordinance that would require 2/3 vote.
Okay, this is Robert's Rules of Order. Because the resolution could be categorized as one to amend after adoption, its adoption would require a 2/3 vote.
2/3, okay.
Robert's Rules of Order, Section 28.
Thanks, Bob.
Yeah, I do have the book.
Yeah, I was gonna say.
And I would say, yeah, but it's not in our specific rules, so, we have adopted this as a, kind of what we follow, but not really. So, knowing that, what would be,
You'll find out after the vote, I guess.
yeah. Okay, very good. We'll do a roll call vote.
No Michael Neese. That was in one of the minutes. My bad. Okay. Campbell,
No.
Gruber,
Yes.
Heinig,
Yes.
Hasley,
No.
Nichols,
Yes.
Polk,
Yes.
Sherman,
Yes.
Varney,
Yes.
and Stegman.
Yes,
That is 2 noes. Motion carries.
all right. Next up, we'll move to item 6, 906 Monroe.
This would be a similar situation, again, asking for consideration of a resolution similar to 249 Hubbard.
Okay. Is anything missing out of this resolution from the last meeting that was approved?
No.
As a condition?
No.
No. Okay.
Mr. Chairman, I move that we approve the resolution for 906 Monroe Boulevard as printed on page 28 of our packet.
Support.
It's been moved and supported. Any other discussion? Mary?
I have a couple questions. Kelly, do you know if have they gotten back to you about the erosion permit? At the
They-
last meeting, it wasn't known.
They have not yet, but I also do not have a building permit application.
Okay, thank you. And like the last time, I had raised the issue, I'm again going to vote no because I do not believe the criteria have been met, again, for 1502C and E at least. The report that is being adopted has not considered our coastal report that was presented in draft form to us at the May 2024 Planning Commission meeting. It was finalized on June 7th, 2024, It was made public no later than July 3rd, 2024. It has not been brought back to us for acceptance since its completion about 3 months ago, but we have seen it, hasn't substantively changed from the draft that we saw, and it specifically addresses the property at 906 Monroe Boulevard, which is immediately north of the high-risk erosion area that is identified by Eagle and is currently in our zoning ordinance. That is from 2018. It hasn't taken into account high erosion, high water issues. That indicated that the hot tub would be going in west of the demarcation that was recommended to prevent building. The report was not being used in this situation to look at setbacks or anything. It's specifically directly related to the 502C, which talks about the health, safety, and welfare of persons and properties through excessive production of traffic noise, water runoff, or other nuisance, and affecting the integrity of the dunes immediately north of the high-risk erosion. Certainly seems like a nuisance. And the reason for not moving it east towards the home out of that area was because the builder represented that the owner wanted to have the best view of the lake, which does not warrant affecting the integrity of our very sensitive dune area. And for that reason, and the same reason I voted previously as no, I will continue to vote no, because I do not believe the standards under 1502 have been met.
Anyone else? All right, we have a motion on the floor that's been supported, and we'll do a roll call.
Gruber,
Yes.
Heinig,
Yes.
Hasley,
No.
Nichols,
Yes.
Polk,
Yes.
Sherman,
Yes.
Barney,
Yes.
Campbell,
Yes.
Stegman.
Yes.
Motion carries.
Okay. Next item. 7, 278 Dykeman Avenue, Captain Lou's site plan review.
Thanks. We have an application tonight for a site plan review for a new restaurant building at 278 Dykeman, which is better known as Captain Lou's. This is a unique site in the B3 Waterfront Business District, and the plans call for the existing restaurant and restroom buildings to be demolished and for a new building to be built in the existing footprint. The applicant did obtain variances from the Zoning Board of Appeals to build in the footprint, and Brad Cotterba from Williams & Works helped us with this review. So I would ask Brad to, if you're willing, if you want to cover any specifics that you think the Planning Commission should know with regard to this review. If there's nothing otherwise, then I can turn it over to the applicant. I don't mean to put you on the spot, but you're here and you helped, so thank you. We can turn it over to the applicant to say a couple of things about the project.
Okay.
Mr. Chair, Planning Commission Board, it's my pleasure to be here. I'm James Marquardt. I am counsel for the owner of Captain Lou and the property at 278 Dykeman. I won't restate fully the presentation, if I can call it that Mr. Doucette put together for you. I'm sure you've all read that, but in a nutshell, I'm going to just touch on two things. I'm going to touch on the fact that this is a restaurant that's been running for 31 straight years. It's, if you approve, it's going to be rebuilt, and it's going to be much nicer. One of the buildings, I'm told, is 100 or more years old, a former fish smoking shed. And the owner, Mr. Talcott, felt it's a popular place. It's time to freshen it up a little bit. And he wants to invest a fair amount of money in rebuilding what is a very popular place. The locals love going there, as we know. As Mr. Doucette pointed out, The variance that we sought was because if we're going to rebuild, it's a legal non-conforming use now. So it's outside of the setbacks, but we're not expanding. And the ZBA said they were good with that. The only other things that I want to address are some questions Ms. Doucette had in her summary. And on page 50, item number 2, she said, we haven't indicated to you on the site plan how the parking spaces will be configured. Let me assure you that there's no change as far as parking goes. There will be no change from the current configuration of the parking. We're not gaining, we're not losing spaces. Also, Ms. Doucette pointed out that we didn't address on the site plan that you've been given how the roof and gutter drainage is going to be dealt with. It's, and also how the public sewer and water will be dealt with in that item 3 on page 50. It's the same sewer and same water that services the facility now will serve Captain Lou's in the future, and there'll be no change in the stormwater runoff. It's collected, some of it has always gone into the river, and there'll be no change. Also, on that same page, item 4, a question arose on the lighting, exterior lighting. We had indicated to the ZBA that there will be no change to that, and that is true still. The existing lights will stay the same when the property is rebuilt, including those low wattage string lights that go around the deck. They will be there as well. It was pointed out to us on page 52, item 12, that we hadn't really addressed the hazardous substance issue. The only thing we can think of is grease. And Captain Lou's has always had, in accordance with law, a grease dumpster, and will continue to use a grease dumpster to collect, store, and ship off-site the grease that any restaurant makes. That dumpster has been used for, I'm told, 24 years. So there will continue to be that issue addressed. The last item that I wanted to address, again, because Ms. Doucette found that we hadn't necessarily addressed it in the document that we gave you, is the soil erosion and sedimentation control issue. Mr. Talcott tells me that all soil erosion and sedimentation control permits have been issued and received, so we have addressed that issue. Are there any questions that you would have for us?
Yes, you have given us a list of things that you say are taken care of. Can those be put on plans so that we have them well documented?
And can you be specific on
Yeah.
what issues that could be shown on the plans? Like, how am I going to show a permit on the plan?
Just give us a copy of the permit.
We can do that.
Okay, show your drainage on the plans. Show where your lighting is going to be on the plans and describe the type of lighting. Show us any signs that you're going to be erecting. Those are the same things that you just mentioned.
Sure.
That need to be shown to us on plans so that we know that they're part of the documentation of this project.
Is it possible to approve the site plan as submitted with the condition?
That's something that we haven't determined as a board. We will talk about that. I'm just asking you if it's possible to do that.
And Larry, I would add floor elevations to that as well.
There are more, yeah.
Yeah. To know how tall, I mean, how, right now it sounds great, but we don't have a picture to say it's this high, this is where this is where that is.
We had understood that the elevations are attached to the document that you'd gotten.
We usually get something a little more.
Are elevations on there now?
Are they?
We saw elevations.
You have seen them now? Okay,
Have, okay.
okay. Then they have been submitted, okay.
Page 65.
All right.
Yes,
Any more questions for him specifically?
Yes.
Before we move
I take
to
it back,
questions
sorry.
for staff.
Yes, actually. It's more, I'm sorry, more of a question of curiosity, given that it wasn't a question that was asked at the ZBA when you're given the parking variance. Had you considered a two-story structure, which would be, you know, commensurate with the surrounding area, that would have allowed for more parking? Understanding, because you've got the variance, so you don't have to change it. I was just more curious.
I don't believe a two-story facility was looked at.
Okay, thank you.
Anybody else? All right, we'll just take a break. If we need you, we'll call you back up. Kelly, maybe you would just want to mention, so we just did the Maritime Museum here not too long ago, and we had a lot of discussion about a building being torn down, and then the parking that had to go with that. Now, why is this different?
So that was something that the Zoning Board of Appeals talked a little bit about, and Clark Gruber is now our Planning Commission liaison to the ZBA, so he can, feel free to jump in.
I think when we looked at the Maritime Museum, they didn't keep their same footprint or even the building completely changed in more than its much larger design, but what that building was offering. And that was an event center that could allow hundreds of individuals to come to an event. In fact, that was part of their business plan, was to hold large events on the facility. So they went from a small building to a building that could accommodate 300-plus patrons in an event. When we look at this building, it's almost the exact same footprint, same number of stools, chairs, same size in a deck. It's not expanding what's currently happening there today, other than taking a building and updating it and improving the bathrooms. So that was what we looked at in zoning board, that there wasn't a large functional change, because the Maritime Museum went from a small museum to the largest event center I think we have in the city. So that really changed the parking plan for that tear down and complete redesign. In fact, they redesigned almost the entire campus versus just almost an update of a building, but by taking it apart and putting it back together. And a big driving force of that rebuild on behalf of this particular client has to do with the project that the Maritime Museum put in with their head, not their head dock, but their seawall has kind of generated, that's like when we were talking about individuals doing armament, you do a seawall, good time to do another seawall and another seawall, and that's just kind of how this project, I think, got started. So that was kind of the differences between the Maritime Museum and what they did and Captain Luce.
Very good explanation, thank you. Any other questions for staff?
For the, so questions about the drawings, would that be for staff?
Sure.
It's just, so it's still one story with it looks like a taller roof? It just looks like overall it's going to be taller.
68, Kelly.
Let's work on getting that rotated.
I mean, what's the current height? Does anybody know? There we go.
So the building may gain 0.4 square feet. And the only difference is the elevation of the lower deck, which is the building that I'm changing, tearing down, because I have to put a seawall in. Maritime Museum put a seawall in. I'm raising that 2 feet. I'm sorry, I don't have it. It is on the drawing, so they'll all be together. The roof pitch, everything is gonna be same. And now it'll actually be one building because the lower building's gonna be connected to the upper building, which is, so it's more in compliance. So as far as the height difference, no, I mean, 2 feet, but it's still single story.
Okay, thank you.
Anything else?
The only thing for staff is if, and I know we've got these in these recommendations, do you feel as though we could put, if additional dimensions or plan for roof and gutter drainage, that could be handled by staff if we approve the overall project? As, you know, if I look at like number 7, they'll indicate on their plan as conditions. You're good with that? It's fairly normal.
It is, and Public Works was comfortable.
Yeah, that's what I thought. Okay.
Most of these items are pretty simple in themselves, but the number of things that are missing on this site plan is something that concerns me greatly. We have these standards that are in our requirements for a reason, and that's so that staff can look at it and we can look at it just once and get things moving. But we've got 11 items here. Maybe 1 or 2 of them have been taken care of by now. And we're still looking at putting 11 conditions on an approval.
All right, so there's a couple things we can do here. You can do an approval with those conditions, or you can move to postpone until these items have been clarified. So let's choose one of them.
Before we go on, I was just curious, recommendation, condition number 4, it says all parking should comply with the standards in our zoning ordinance, but shouldn't there be some reference to the variance from the ZBA in number 4, except as modified by the ZBA variance?
Yeah, it was, and in fact, I was unaware of the modification for the variance until I contacted Kelly. I was speaking to a Carrie today.
So would you recommend leaving 4 as is, but then referencing the
Correct.
ZBA variance?
Yes.
And what was the date of the ZBA meeting? Oh, it's right here, July 22nd. I appreciate that there's several items outstanding, but I also, with it being a tear down and rebuild, and it sounds like it's very similar to what we have now, I'm less concerned with seeing them before approval. If Kelly is comfortable, if something is awry, maybe one of the conditions is that if Kelly believes the planning commission needs to re-review, she would bring it back for review. Would that be an acceptable condition?
Yes.
That
I mean,
sounds interesting and reasonable, and at the same time, maybe additional information for staff to know that this is a big number of outstandings, and next time an applicant comes by, you can tell them, like, guess what? Planning Commission doesn't like to see this number of conditions.
For me, this time, it's too many.
Me too. I'm struggling with this one.
So I would.
After we just had to
I'm
redo
wor-
something for
I'm in
documentation.
favor of the postponement until most of these are met.
Yeah, I get 4 or 5. I get 4 or 5 because they're usually the same 4, they're the same 3, whatever. You know, we see those. This is things we don't usually see. So I told this to Kelly today when I talked to her, like, oof, that's a big list. I don't know how I feel about that, but now I know.
Is there some reason why this wasn't mentioned in the beginning, before tonight's meeting?
Yep, we work with all applicants in advance of the meeting to try to prepare as best we can.
Typically, we're looking at the first three. That's pretty standard boilerplate.
Do you have something you'd like to add?
Mr. Chair, yes,
Yeah.
I would like you to know that timing is an issue for us. The seawall, if approval is not obtained here at this meeting, the seawall will have to be postponed until next year.
All right, that I understand, and we could probably break that one out.
I gotta tear it down to do the seawall.
The building?
Mr. Chair, may I also ask this? Would the Planning Commission be open to putting a defined number of days on the revisions to the site plan and get them into Ms. Dissette's hands? And I think we'd be open to that. Thank you.
You know, another thing when it comes to these items and what staff prepares here is that, and I'll give you an example. The applicant shall indicate on the site plan how roof and gutter drainage will be handled in the new building. Anything could be drawn up after the fact of the approval. Then maybe it doesn't even fall into the city code on how it's to be built. It's hard for us to make a decision on gray stuff like this.
I wouldn't approve that. I would send that to the city, to engineering for approval. Any site plan provided back to me, any revised site plan is also provided to engineering for review.
And it's another thing, you know, like if something has to be demolished for a seawall to be built, that's different than the rest of the construction, is it not?
The seawall, as you remember, was approved separately by this body. But we're hearing from the applicant that the project is tied together. They'd like to do all the demolition at once in order to then construct the seawall, followed by the restaurant.
Don't most of these comply with, or they're the rebuild, they're not the demolition, correct? I mean,
Well, the demolition would be handled via building permit.
okay.
Yeah.
So it's up to you guys, whatever motion you want to make.
May I ask, so, with time being of the essence, is the concern that you do not want to demolish until you know that you have approval of the construction?
I would think so.
Yeah.
But the approval of the construction only comes with all the proper documentation.
Understood.
So, and it's, we encounter this all the time. Everybody drags, and I'm not saying you did, but a lot of people drag their feet, or they're working through multiple engineers or architects, and something slows down, and just, it's always late. I get it.
But we're still doing an approval that's conditional on meeting the requirements within a motion, and staff still has the final say as long as the items are taken care of. So the items will be taken care of. Yes, it is a much larger list than I think I have seen. That is a true statement.
And you're saying you're giving staff carte blanche on this to make, that none of this would come back to this board for review. And I'm not saying I don't trust staff, but it's so many.
There are so many. I think Mary had a good item to even add another one, but that is more of a clerical, that if Kelly feels like she needs to bring it back, she could. And then Kelly has that ability to say, I'm overwhelmed, and not overwhelmed, feel like I need additional direction for approval beyond the skill sets that she and her team has.
Or could we go further and say, call this preliminary since there are still 11 conditions, and that we require coming back regardless of how hard it is for Kelly, that we need to take another look at the site plan X number of days. I don't know if that's within our authority.
We'd have to call a special meeting.
I do love meetings.
I do, I don't want to, book anybody's time, but it would make me feel better that all these conditions were met and we were only approving the standard 3 or 4 that we usually have to, because we require everybody else to bring us a completed site plan. And if we're going to, do one for the other, I realize that time is of an issue, and this happened a lot right after COVID with all the building construction issues and delays and things, so it can be amended. I understand that, but I also would like it to be complete before I approve it.
And the biggest one for me is item 8. Elevations. How do we not have elevations for this project? I'm out of any of these. I mean, what's the floor elevation? If we're doing a complete tear down and a seawall, there's got to be an elevation on the seawall to start with, and where are we going from there?
Yes.
Could the applicant comment on the timing aspect of by when at least half of these could be completed, so we only have, the 3 or 4 standard ones, and try and see if we have a quorum to do a special meeting to get this proved, to get it going, because I would hate to have it delayed for another year.
That's a great question. If my engineer could do it in a timely manner, that'd be great. I can't get him to call me back. I knew about the elevations, like I explained earlier. I couldn't get him to do that note. I don't know, he's on vacation. I'm 100,000 in just on drawings. I haven't done one thing. And the site, there is no change. The lights are the same. The sewer's the same. Everything's the same. And I paid him to do all your answers, but now that's not enough.
Well,
That's what I have to say.
And because of the similarity of a demolish and a rebuild of a business that's been here a long time, and some of these, there is a long list, but number 4 really is a non-issue because he's gotten the variance from ZBA. So that's just incorporating the ZBA. So I don't really see that as a concern. That's been resolved. About the exterior lighting and the signage, those are all post-construction, and I would, in light of it already being there, I would expect it to comply or be able to work with Kelly to have it in compliance. If it's draining the same way it's draining now, again, that is less of a concern. If they were redoing, like the Michigan Maritime Museum, then yes, that's not a question. But because it's a rebuild in the same footprint, that's why I was more willing to accept these numbers, because they didn't appear as significant under the circumstances. I would move to, I would move to approve the site plan, subject to the recommendations proposed in, that the proposed development be approved, subject to the following conditions. 1, prior to the issuance of any city permit, the applicant shall have paid all application permit reimbursable escrow, and other fees related to the request. The site plan shall fully conform with this ordinance and all applicable city, county, state, and federal statutes, rules, and regulations. The applicant shall submit all site plan materials as necessary to the zoning administrator, and that the administrator will bring back to planning.
Hang on right there. So this is where she's changing what the recommendation is. Okay.
Shall determine whether any items submitted need to come back to planning commission for review before a permit is granted. All parking should comply with the standards set in Article 18 of the zoning ordinance as with understanding as modified by the zoning board of appeals, variance granted at their July 22nd, 2024 meeting. Any exterior lighting must comply with the standards set in section 1710 of the zoning ordinance. All signage must comply with the standards of Article 20 of the zoning ordinance and receive an approved City of South Haven sign permit. The applicant shall indicate on the site plan how roof and gutter drainage will be handled in the new building. The applicant shall indicate finished floor elevations of the new building on the site plan. The applicant shall note the dimensions and orientations of the decks, walkways, and patios, as well as their uses. The applicant shall maintain compliance with all applicable fire and safety codes. Earth-moving activities necessary to reshape land consistent with the site plan shall comply with the Natural Resources and Environmental Protection Act, PA 453 of 1994 requirements. Did I?
Yeah.
I want to interject before there's a second.
Okay.
We have the same problem here that we had with the resolutions earlier. There have to be findings, and a simple way of doing that, if the commissioner would agree, is to adopt the findings of the August 21 Township Planner Report and the August 8 Staff Report, so long as all of these conditions are met.
Okay,
And-
repeat that for me again.
Yeah, we also technically, under the law, have to make the findings that the standards are met for the site plan.
Right.
So if the commissioner would agree to add it to the motion, that motion would also accept and incorporate the findings made in the August 21 City Planner Report and the August 8 Staff Report, contingent upon the applicant meeting all of the conditions in the motion.
Okay, it was the August 21st Planning Report. I thought I heard a different date also.
I think, Kelly, correct me if I'm wrong, I think Brad had the August 21 Planner Report, and you did the August 8 Staff Report. And I think they both have findings in them, or am I missing something?
No, I'm only finding the,
I was just looking at the dates on the two reports.
So August 8th was the previous meeting. So the meeting for the,
But they're both reports. I think each of you did your own report, did you?
not for this,
Not for this, then I'm
item.
wrong. So it's
correct, just August 21st.
I stand corrected,
Yes.
just the August 21st Planner Report.
that's where I was getting confused because I was
Yes.
only seeing one
Only
report.
one.
Apologize.
Yes. One.
It's a thick packet tonight.
Okay. All right, now I know where you're going with that, so we'll hang on to that for a moment and just go with your motion as is. If there,
No, I believe that it,
The one report is applicable.
right, that,
she can, yeah. But I had a question, it was item 4. You referenced the date on that, but you don't have to talk about it right now. I want you to get your motion complete.
Item 4 was the July
Like-
22nd Zoning Board of Appeals.
22nd,
yes.
yeah. ZBA, okay.
And that the planning commission accept and incorporate the August 21st, 2024 planning report related to this site plan application and its findings,
So long as the applicant meets all the conditions.
so long as the applicant meets all the conditions.
Thank you.
Thank you. Good thing I brought my good reading glasses.
Okay.
Second.
It's been moved and supported. Is there further discussion? So the one concern, though, even though if this gets approved, is you still have to meet all those conditions before you can start. So hopefully you'll be able to get in touch with your engineer. And if not, it'd still be useless. And it puts you on the timeline for actual construction after approval.
That's true. I will say that there is approval for the seawall work, so there would be some demolition with demolition permits that could occur, and work on the seawall could also occur, because those were approved separately as separate approvals.
Right. Just that, though.
Correct.
Okay. All right, everybody good?
Yes.
Okay. You want to do a roll call, or you want to do a straight vote? Roll call?
You got it.
Yeah.
Okay. Heinig,
Yes.
Hasley,
Yes.
Nichols,
Yes.
Polk,
Yes.
Sherman,
Yes.
Varney,
Yes.
Campbell,
Yes.
Gruber,
Yes.
Stegman.
Yes.
Motion carries.
Okay.
Excellent.
Next up, item 8, public comment. Citizens in the audience may address the planning commissions regarding items not on the agenda. And seeing we have empty chairs, there'll be no public comment for items not on the agenda.
Do you want to run around and say something?
Mr. Chairman?
Yes.
Could I ask for a short recess? Very short,
It's not 9 o'clock yet.
very short,
I
before we
would-
get into the next item.
Okay.
I would move for a 5-minute recess.
Support.
It's been moved and supported. Any other discussion? All in favor, aye?
Aye.
Aye.
Opposed?
Did you see the US Open this week? Oh,
I've been watching like crazy.
one of the girls literally
That
had to go to
was,
the
yep,
bathroom.
that was the first.
Oh, that's not uncommon. That's not uncommon.
And at the end, their interviewer, she finally said, what can I say? I had to go.
We bounce people for less.
I think that's good, and I.
It was classic.
Caution
You know, like, can you imagine trying to run if you've got to go? Like, come on.
Hey, I'm really looking forward to Tiapo.
Sorry, again, it was purely because same footprint, representing same lighting.
I was saying to him, like, if
I
you
watched
just
him in Cincinnati multiple years down there.
No, and they can tell.
You'd be so much fun.
Exactly, yeah, but, yeah. No,
Women,
but
Navarro.
Tell you the one
Jeremy's
thing
excellent point.
good about what
They
we're
say it's
doing.
gonna be the same, but until we see it on paper, I
They're
know.
now taking that piece of property
Just
out of
like,
the minds
you
of
say it's gonna be
American.
There'll be at least one American man in
I
the
know.
They will not want
I
it
know,
anymore.
but that's true with
Because they want it to be
anything. I know, and
South Lake is gonna be hard to beat.
I mean, I think he's owned
And I
it
think
for a while.
when the project is done, I think it really will add
And we
back to the
really
attraction.
need to-
Oh, yeah.
Especially, you know,
It's a busy place.
it's a busy
right there
place.
at the bridge.
Yeah, it is.
Minor, it sounds like
But I
he's
know
just having
A lot of people, you know, they wanted to incorporate into the whole campus, but
his
by
architect,
redoing
and
it all,
that
that's
just
a no point.
pulls at my heartstrings. I know. Because he's caught between a rock and a hard place.
It's a shame. I remember as a kid going there.
Same here.
Van Jensen and.
Same here.
And, what was his name? Marty? He tended the bridge too.
Yeah.
He worked for.
Yeah.
But now it's the urinal. The smokehouse is, they're back.
Is it really? I haven't been there in years, but I can remember growing up and just really enjoyed that place. Well, it was Jensen's.
Yeah, smoked chub,
Yeah.
all that, shrimp.
Shrimp, yeah.
Gordy.
Yeah,
Gordy was the
Gordy,
guy's
Gordy.
name.
Gordon.
I think he lived over on Superior Street.
That's right, I was thinking I could put the sun out.
Yes. So that'll be another historic building from South Haven gone.
I'm sure we'll have those historic pictures to look at.
Well, that's where he lived. You know, and then the other part that's closer to the museum, that was the store, and where they cut the fish off. And they were the last ones standing. State went to the lottery system, and his name didn't get drawn.
Doing computer work all morning, and then I was
State
sewing all
paid him
afternoon.
money
I'm like,
for his
okay,
boats and nets.
should have gotten outside and done something,
Gave
but
him
I
to
didn't.
some of the tribes up
New
north.
denim
Oh,
jacket,
really?
you know, you're looking a little
I know,
threadbare
I'm
out
looking a
there.
little
I know
threadbare.
that's stylish.
It is
$10
stylish,
of
isn't it?
course.
Yeah.
I do have
Goes-
another
It
one.
goes with your jeans that are.
It does,
torn to
but I don't have
shreds,
those
right?
on today.
I know, but-
Usually I do. You know I do. I always have jeans with holes in them.
I think that's why they
Or
cut
I've got
the
them
one
kind of
fish
fold
tug.
up so they're ratty.
One
I like,
that's
I
at the
like a ratty.
Maritime Museum now,
Ratty look.
because
Now that I
what
don't
they
have
were
to
offered was
Go to the office anymore.
Nothing.
You know?
nothing.
It's like, huh, I can wear what I want.
We'll just
But that's
use it to
interesting, as we
drive around
moved
the
away from
port.
traditional jobs and.
That's okay.
I remember when I wore a
It's okay.
jacket to work every day.
Yeah.
A suit or sport.
I don't think it, you know,
And then we went to
change
casual
by two or
Fridays,
three.
and then we went to
that's not
casual all
gonna
day.
change because there's not big enough scope to change it, so such to be interested.
Yeah.
Items.
No, I never wore that. I didn't wear that, I didn't wear those to work.
Fact from this. and fact
We
from
were allowed to like wear sweatshirts though, and I always thought that was a little
Yeah.
casual too.
But I hate during
little
the
too
meeting
casual.
to put something, I
I
need
thought
to
before
remember
we
to bring
just
a
went
sweater
through,
that I can slip on
Like
easily
what
and I had
Brad
to pull over my
posts
hat.
then, I thought that's all we had to do.
It's your fault. What-
Yeah.
Yeah.
Okay, back room. You knock on the door there and see if he's ready.
It's what you have to do when you come to the meetings. You're the timekeeper.
You can't, you'll have to knock in.
Land Shark,
Ready? Volume on?
Candy Graham.
All right, we're gonna call the meeting back in order. And some unfinished business is the item 9, proposed zoning amendments. Sections 1743 and 44, short-term rentals.
Yes, thank you. As you are all aware, during the first months of this year, the city council worked with the city manager and municipal attorney Cliff Bloom to develop proposed amendments to the aforementioned sections of the ordinance related to short-term rentals. And you all briefly considered this text at the July meeting, but there were questions on 3 items noted in the original council motion, sending the amendments to you for additional clarification. And you do have written communication in the packet from the city attorney related to these items. As a reminder, some substantive changes to the zoning text include the business unit saturation controls and annual allocation process that was described in section 1743 were eliminated. And this language has been replaced with a hard cap on the number of short-term business rentals permitted in the city. This change will eliminate the annual snapshot report and any potential lottery. There is still a list of developments that are excluded from the cap that's similar to the list of developments in the ordinance now that were exempted or excluded from the saturation ratio. These are primarily PUDs like Harbor Club, Trailside, and some attached condominiums. There are also some changes related to personal rental unit regulations, the fee language. We talked a little bit about this last time in section 1744 has been modified so that fees are set by council resolution and property owners will need to qualify for a personal residence or primary residence exemption in order to obtain a personal rental registration. So, Mr. Chairman, we have the city attorney with us tonight. We need to discuss this text and then discuss next steps, so.
Okay, is there anything you'd like to add?
Briefly, Mr. Chairman, Kelly
Sure.
did a good job of summarizing it. The city council made its motion on June 3rd to pass this on to you for consideration with the three issues that were open that I addressed in the email of July 30th. This is unusual. I mean, obviously, normally an ordinance would start with this body and would make its way to the city council. I think there was a feeling that they wanted to give the planning commission some guidance and suggestions and so on, because this was such a major issue. And the city council and staff actually spent a lot of time on this draft. So I think it took a while to get a consensus on that. So that's why we're here today, and I'm glad to answer any questions or concerns.
Okay. Who wants to start off?
I'd be happy to. I just have like 4 overarching questions. First one is, it's always good when you amend or draft an ordinance as a body to have objectives of what you're trying to accomplish by doing so. So were there objectives that the city council set that we can use as a kind of a review guide as to the changes that were made? I mean, what were the actual objectives?
I don't know that there was ever a list prepared, and keep in mind, at this point in time, it's not an ordinance format per se.
Right.
And eventually, it's possible that we'll actually put some findings and so on at the beginning, but I think the council had many objectives, or individuals spoke, but as far as a unified objective, Kelly, I'm not aware of any written. Obviously, the big issue, and we came into this new, we became city attorneys shortly after the first of the year. We've worked with a lot of other municipalities on short-term rentals. This is probably right now the hottest issue for the majority of our municipal clients. I think perhaps the overarching concept that I came away was that the lottery probably was not working. It was very complicated. You were up to 20% and so on, and there seemed to be pretty much unanimity on that. But, council member, I'm not aware of any written objectives.
Okay. Second question is, and I ask these because a lot of this was in closed session, I believe, a lot of discussions. There's nothing in the revised ordinance about density, something within 250 feet or, 2 per block, whatever you'd like. I know that was a discussion point, I think, back in 2018 even, and it was found probably too hard to accomplish. Was that discussed and thrown out, or was it not even discussed?
Yeah, again, I can't really get into what happened, but in general, I do not recall in the open sessions or with staff a discussion of density or setbacks. And if I could, I should have mentioned this to the chairman earlier. Our recommendation was to do the zoning first, because it's triage. The city council staff and our office have been working on the separate regulatory ordinance, which is probably 3 times as long as this. We'll go into a lot of detail. Your issue is interesting. I'd have to think about it and discuss it with staff, whether you would put, whatever you want to call it, setbacks between short-term rentals and the zoning versus the regulatory. I can think of arguments both ways.
Third question, can I assume the answer you just gave about density is the same for overlay? Probably not discussed.
What do you mean by overlay?
Just having overlays within certain neighborhoods where it's intended for there to be a much more dense population of short-term rentals, whereas in other areas, it would protect the character of the neighborhood by not having as many.
I don't recall a discussion about overlays per se. I mean, in general, we had discussions with staffs and so on about problems in certain neighborhoods versus other neighborhoods, but I don't think the idea of an overlay was ever explored.
And then the final question is around what I consider somewhat complexity of the existing ordinance where we have, exempt personal, non-exempt personal, we have exempt business and have non-exempt business. Was there any thought of just having one set of standards that apply to all?
I don't believe so. I think we didn't want to reinvent the wheel because people had relied on the format and so on. We tried to make it clear. I think maybe we clarified some of the wording, but no.
Thank you.
You're welcome.
Maybe I could add, yep. My understanding with regard to the lottery is not that it wasn't working, it had actually never been done. And I think one of the biggest concerns of residents, at least that I'm hearing, and I know other council members are hearing, is enforcement and compliance. I mean, even now, people with personal short-term rentals are supposed to submit their rental periods, and that doesn't happen, and there's no enforcement. Regarding density, I know that I know some city council members have been concerned. I know some areas have been much more impacted, and I know certain areas are very concerned of similar impact and are trying to avoid that gentrification. So that has been a concern, and I think has led to the priority to redo the zoning ordinance, possibly due to so much being discussed that some items didn't have time for discussion. I know I had provided Kate a comment about overlay because some areas are more amenable to short-term rental, but it appears not to have been remembered in discussions. Again, we discussed a lot, but I know I had suggested an overlay in an email to her, like in April. One thing that I think is missing from this that we had in the previous is that Sherman Hills was to be stricken, and that hasn't been stricken. And I'm concerned that there may be some ambiguity with regard to attached condos, because I'm quite certain that there are some dwelling units that are identified as attached condos, but they are cottages and are not attached. So that would need to be clarified. For this one issue that I have been raising, and I still struggle with it, is the lawfully existing as of December 31st, 2023. The ordinance was amended in 2018, I believe July 2018, and that changed how things were looked at and what would be considered grandparented. And that language has been stricken, so I'm concerned of issues arising from that. But that was one issue that I would, like I said, am struggling with, is as of January 1st, 2019, things changed. Occupancy was supposed to be 12, and whether certain things was existing or not, that it's not as noticeable in the zoning ordinance. But once you combine the zoning ordinance with amendments in the regulatory ordinance, I think that's where some confusion is ripe to occur, some ambiguity. And that was why I was I requested that I wanted to see both the regulatory and the zoning to see how they meshed. And with changes in definitions, I am concerned that the lawfully existing will allow things that are currently not lawfully conforming to become lawfully conforming. I appreciate that there is a list and concern about setbacks and things like that, but the list of 5 items is really, I don't think, the concern of the residents. I believe the concern of the residents is compliant with the short-term rental ordinance as it is written now with regard to on-site parking, what's a bedroom, what the occupancy should be, and that's all part of the review process. So that shouldn't be as onerous as the email would make one think. And so that, I still want to have further discussion on that, because I don't want something that is not lawfully conforming right now to inadvertently become lawfully conforming because of changes of how definitions are in the current regulatory to the next regulatory. For demolition, I'm a bit concerned with the reference to lawfully non-conforming status, because for the short-term rental permit to continue, it needed to be lawfully conforming, at least with the short-term rental. And I don't want that to get lost. I know there was reference to things started in 2023, but in January 24, we have a new city council. I think the composition is different. So to this extent that things are relied on from decisions in 2023, those really need to be readdressed. For the cap, I did raise a concern without having a number for the cap, that there's the inference that we're trying to remove all short-term rentals. And I don't think that was ever expected. Everybody understands that short-term rentals are part of our community. The issue that brought this all about is having reasonableness balance between the number of short-term rentals, which really is a commercial operation in our residential areas. Without a number, the rhetoric is that people are trying to eliminate short-term rentals, and that is not the situation. We are trying to have a reasonable balance of these commercial uses in our residential districts. And I know there's been a lot of discussion about transferability. I know in the regulatory, we talked about transfer of the permit. But in light of the fact that, in January 1, 2019, the way the ordinance was written, there was supposed to be a difference. And I would like to understand transferability with that interpretation. That is it.
Can I respond briefly?
Yes.
With regard to whatever you want to call it, density, separateness, not a lot of municipal ordinances have it, but some actually do have setback. They say a new short-term rental can't be located within 1,000 feet or 2,000 feet or whatever beyond that. The cap will have a number in it. Staff just has not figured out that number yet. And there's no use on doing that if, for whatever reason, ultimately you take that language out. So that's a placekeeper. The intent is definitely to have a number in there by the time you have your final recommendation and city council makes its decision.
But is the number going to be the number we currently have? Or, see, my understanding is the cap is what we're working toward.
No, the cap would be the ones that are legally out there, the business ones as of December 31, 2023.
That are legally existing. And that is my concern, is that without a lower number, just being, that it will be ratcheted down without a number to which the target number for the ratcheting down, there is the misunderstanding that short-term rentals are trying to be eliminated because there's no number, so it's being ratcheted down to 0.
Well, It's only ratcheted down if someone doesn't renew or they're found not to be lawfully in existence. So the odds, let me just throw out 700, just take that number. The odds of that going down to zero is zero. I mean, you might have over several years, because people decide they don't want to do short-term rentals or they're found to be illegal, it might go down 10 or 12 or 15 or 20. So obviously, and that was not discussed. If you or the council want to put a floor on it, you can do that. But that wasn't the concern. The concern was not to let it keep going up and that it would ratchet down as people gave it up or so on. But you can do a floor also.
So I think there was a misunderstanding because I know that some city council members have gone on record with a floor number. And maybe the misunderstanding is some believe that the number legally existing in 2023, December 31st, 2023, is the floor. Although I understand the ratchet. Again, that is something that I think we need to clarify, because I do know that there's rhetoric out there that because there is no number, there is no floor number, all short-term rentals are trying to be eliminated, and that was never intended.
That has never been raised with us, but that's certainly, obviously, something the Planning Commission, Township Board can put in the ordinance if they want.
And I do want clarification on the legally existing, because
We've addressed that several times, and hopefully staff either has made that available or will make it available to the Planning Commission. We respectfully disagree. It's like the dock, that you got to jump off into the deep water and not know what's there. This is true for your whole zoning ordinance. The lawful nonconforming issues are not just in the short-term rentals. There's no way of inventorying, whether 700 or 650 or whatever. You really have to do it on a case-by-case basis. And the regulatory scheme, as we've discussed, is out there. If the zoning administrator gets a complaint, investigates it, and finds there's a violation or there's not, the property owners or the neighbors can appeal that to the ZBA, and the ZBA will make a final decision. But Michigan law is just crystal clear. Once someone has a lawful nonconforming use, you cannot take it away unless they violate. They violate the zoning ordinance, the registration, or the regulatory ordinance.
Well, I'll continue to think of it. Like I said, I know our current ordinance references January 1st, 2019,
But we've got a whole series of new ones that have come out since then. And again, we're always happy if you or anyone else has some language that you think is better, we'd be glad to look at it.
Thank you.
Thank you.
Oh, just two of them. I think my understanding was that, and I was very involved in 2016 onward, that we had come up with how to calculate a cap. We had suddenly come to the first time of hitting whatever that 20% was, and the lottery was something that was coming, and we didn't get to the lottery. Now, I do believe a cap is something, the goal that council has, and it's probably, from listening to the meetings, some number less than the current number, and that's a cap. That doesn't change or take away anyone's ability to do their short-term run if they currently have a business STR. Now, over time, someone may give one up, or the family doesn't want to do it anymore, or they miss and forget for a year, that number is going to come down. And I think what that then does is we don't issue any new until suddenly we come under the gap, making it easier for staff to know whatever that number is. And I just pick a number out of the air of 250. So it'd need to come down 26 before we issued any new ones. And then at that point, hopefully there's some ability in the other of how to, who gets that one if somebody wants that one. Now, I think one of the benefits that we looked at early on and did not adopt was the personal STR based on a PRE. Now, that was kicked around as an opportunity, and the reason we went with a personal STR was, like, community input was that many individuals had the wealth and opportunity investment to have a business STR. What about any other resident within the community who didn't quite have that ability? And we said, look, if you live here, we can let you do it at a much smaller scale. And the intent was a personal reason for doing that, not a business reason for doing that. I think if we had adopted the PRE, we wouldn't see that large number of potential personal short-term renters that are doing things beyond what a personal STR would be, because we would be looking at a much smaller number of individuals who this is their primary home. So I think that is a good way to look, and I wish, had we had that before, we may not even be here now, because I think it was the increase of that number. So I think that is a good put into this ordinance. I'm a little concerned with the 180-day calendar individual being able to enforce that. I think the flat-out PRE,
That was stricken.
that was the stricken, that is the part that was stricken?
Yeah, go to page 94.
Okay, that looks like it was underlined as opposed to strike
No,
through.
that was stricken.
Thank you,
Page 95.
thank you.
Mr. Chairman, if I can, the final version, I believe, is the May 28. And the earlier one that has May 14th. And by the way, I made the same error earlier today. I kept thinking, and then I realized there was a May 28th.
It's, yeah, okay. That being stricken, I think is right, and just let the PRE stand on its own. I really do think that is that's really what was needed originally. So then we knew that individuals who lived in the community, and that was what we wanted to provide, an opportunity to have the ability to do that. Those are my comments.
Okay. Anyone else? No? One question I had is regarding the fees. Although I see council can set it by resolution, I'd like to see some parameters around that. And we've talked before, there was per unit or by square footage. And I think basically you can only charge as much as it costs to administer. So, I don't know, it seems too gray yet for me.
Tim?
Yes.
Can I respectfully play devil's
Sure.
advocate? I don't think we've done that with other uses, have we? Put a limit on what the fees could be set? So
Not that I'm aware of.
You certainly can do it. I mean, the ordinance can say that, but I think the idea is it's so hard to anticipate what's going to happen in the future and so on, to give the council discretion. I mean, it would have to be approved by council. Staff could not set it, but.
Well, I'm thinking about, okay, so you're ratcheting back each unit. So now the fee gets larger and larger for each remaining one. Some of these homes are way bigger than other ones, and I think it's disproportionate to make the smaller ones pay the same amount as the larger ones. Because each year, if it keeps dropping down, and if there is a floor, the costs are basically the same, right? For administration, the staff's still the same. There may not be as many inspections.
Right.
Mary?
So I have heard that from other constituents, that an efficiency apartment in a condo complex doesn't take nearly as much time as a 7-bedroom, 6-bathroom home for all of the inspection requirements, and that there should be some sliding scale based on the amount of time that the inspection takes.
So that's why I'm saying in here, we'd have to identify the method.
Wouldn't that be in regulatory? Couldn't that be in regulatory?
Probably not if it refers to the zoning fees, but again, the question is, when it's in the ordinance, it's pretty much in stone. you make a very good argument that the council ought to adopt a resolution that has a sliding scale or whatever. It's just, the question is, do you want to handcuff and put it in the ordinance to make it definite? So that's it. And then one of the other problems is, hopefully inflation's not going to go up a lot in the near future, but if you lock it in, although you implied this earlier, Mr. Chairman, if you still say it's got to roughly reflect the costs of the administration, that limits it a little bit.
Right, because the devil's advocate on this is if you had a completely, let's say, anti-short-term rental city council, they could raise the fees so much as to make it insane.
Agreed.
And so how do you control that too? That was one thought. What was the other bullet point? I don't remember.
I have another one, I'm sorry, I'm coming back.
That's okay.
Okay, and that is,
Waiting for Janice, but
I know.
Janice isn't saying.
I will do after Janice.
Okay.
I agree with the density. I know we discussed it early on.
Janice,
and
pull your mic
that
down.
was that was a question, but the thing that stopped it from going further was how do you manage that, or how do you determine that? And I don't know with our new technology if that is something that can be determined more easily than previously. When we talked about density, I think staff thought it might be burdensome to try to regulate that piece. The other one is the floor. I think that that's important to where are we headed down toward. And the lawfully existed phrase, and this may not help at all, but rentals that were registered and recognized as STRs as of December 31st. I don't know if that would help with that. No, I thought it was deeper than that. No. Yeah. So those are my comments.
Okay, thank you, Janice. Now Clark.
Okay, when we were talking about approved underdeveloped or partially developed plan units, PUDs, one of them still listed is Maplegate. And I'm not sure if Maplegate is underdeveloped or partially developed. I thought that was fully developed with all of the homes. And
I believe it's fully developed too, from my personal experience.
So I remember the intent was we had PUDs that were highly underdeveloped, and this helped fill out many. Certainly Woodland Harbor and Trailside Phase 1, and I think also Maplegate. But now seeing that Maplegate is completely filled out, I don't think that should be excluded because it's full. And it says right in there, dwelling units within the city-approved underdeveloped or partially developed plan unit developments and name them. That one is fully developed, so I think it should be removed, in my opinion.
Mary pointed this out, there's so many moving parts in this.
Mm-hmm.
And Kelly,
We live
maybe-
here, so
maybe-
it's easier sometimes to go. I run by there 3 times a week.
Maybe you can help me. Is the problem that I don't have the word undeveloped, developed, or partially developed? Or wasn't the intent that regardless of whether one of these properties or all of them is developed, they were going to be exempt? It wasn't the fact that a development had not been developed yet or was undeveloped that would make them exempt. It was that the council seemed to indicate that all 4 of them are just going to be exempt.
I was on council when we put that together, and that was the reason we put it together that way, is we had developments that were highly underdeveloped. In fact, I think Everett Park had 1 or 2 houses on it, and now probably has 25, 30. So
think just
that was
20.
the reason to put that on there, because I felt like that would spur development of those PUDs. And it certainly spurred the development of Maplegate, because now they're completely full. So I don't, that's why we put those in there.
So are you asserting that the developed ones should be subject to the caps and registration and so on?
Because they've developed. They are now part of the community fabric of what I would consider a developed neighborhood.
And I would support a recommendation to that effect to the city council.
And see, when we started this, I had said that every dwelling unit should be part of the count.
Yeah,
And
you did.
And you guys well, I don't remember what you specifically, but decided that no, certain developments were gonna be exempt,
And that's why that was put in there.
so.
I wanted the density, and that didn't get in, you know, but as a body, we created something, and then it moved on to city council, and
If
breathe
that's
life into it.
ultimately the way you go, and if city council agrees, we're probably gonna have to define what developed is. Does that mean 75% of the units are built, or otherwise someone's gonna say, well, unless 100%?
then I guess we would, need to come up with that, but I'm good with that, because that was, Chairman brings up the exact reasoning. And also, he did in fact say we should put them all in, so.
And every year, there's an annual report of the number of dwelling units in South Haven that I used as reference material for percentage.
So that report will no longer be created under this version?
Not the
just-
city's report, this was a federal report
Oh, okay.
that said how many dwelling units. They put it
The
out every
census-
year.
The census report,
And
yeah.
you could say, okay, out of that, using that as the baseline, here's the percentage, this is how many permits you can have. It was nice and simple, but it got way complicated.
And I would encourage the planning commission to consider, also having the condominium units excluded. I believe one reason that was left in there is there's the thought that the HOA would control which would be condos or not. It's my thinking that the condominiums, the apartments, those tend to have the smaller footprint, tend to have the lower price, unless they're right on the lake, of course. And those would be the stepping stones for a workforce family coming in, buying the smaller attached condo units. And having them excluded and being able to be income producing inherently increases their price.
I have a question regarding Maplegate. Was that considered a PUD?
Yes.
It was, okay.
Have we solved anything yet?
Not yet.
Because
We answered any of your
recommendation,
questions.
Kelly wants us to review and discuss the proposed short-term rental ordinance amendment language and any changes that you guys want to make. Are there any changes that you want to make?
Oh, I'd like to remove just Maplegate from the PUDs that are partially or underdeveloped.
And I want more specifics on fees.
I've been keeping a list.
And I don't like the hard cap, because you're always building new units. I think the cap can
It's
actually.
not a hard cap anyway, as long as it can be decreased on an annual basis, it's not a hard cap.
But it's a bottom cap.
No, well, there isn't one of those in there.
Hard cap up or down.
Mr. Chairman, obviously,
Yes.
it's preliminary review, and you're going to go through the public hearing, and things could change, but the list I've been taking of issues, density or separateness, should you look at an overlay district, ambiguities regarding the attached condominiums, lawfully in existence, should there be a floor, should the fees be set or at least tied to only reasonable fees for the costs? is it Maplewood?
Maple Gate.
And whether or not to make the condos, I wasn't real clear on that, exempt or non-exempt?
Not exempt.
Exempt, not excluded,
And
using the new language.
Whatever kind of consensus you have on this, even if it's a loose consensus, we can revise this before your public hearing, get you a red line version also.
Well, I don't know about everybody else, but I think the square footage or bedrooms or something should be
Yeah.
used as part of the fee calculation, not just same price across the board for all units.
I think occupancy might be something to consider. If occupancy is 6 or less, the fee is A, and if it's between 7 and 10, it's this, and if it's 10 to 12, it's that, whatever, but a sliding scale
Just
based
like
on
we do with
occupancy.
the marinas, you bring your
Yeah,
boat in,
exactly.
we've got, it's $80 per linear foot per night.
And the beauty of doing bedrooms or occupancy is that number is already known and recorded, as opposed to square footage where you'd have to send somebody out and do the
All the
calculation.
tax things have your
Oh,
home
that's
square
true.
footage, it's
That's
already
true.
there.
And I keep going back to this cap. Either way you say a cap, I think that's what's sending people off the deep end of, we're trying to get rid of short-term rentals. Instead of a cap, like, we're just trying to manage the number, is the language we have to use. And I'm not sure that cap is really helping anybody. I mean, we're just trying to keep it under control. That's all.
And that's where I say if you use that federal dwelling units per year, you say whatever that number is times 20%, 15%, 25%.
That's where we started.
where we
And we
started.
got all
Some of that.
complicated.
Yep.
And here we go again, getting complicated. The truth is, every time we have talked about this, everybody says, what is that in hard numbers? So everybody's got in mind a hard number. Why are we playing around with all this other stuff? Let's just name a number and go with it.
Well, because the number changes as new construction happens.
No, it doesn't. We just took that out.
We did.
Oh,
We did. There's no, and so I would say, I think that some of these concerns about neighborhood level density maybe don't come into play on this text because we're not granting new certificates.
If you talk to any member of the board, they will give you a number that they have in mind.
Yes.
That may not be the same one. It probably won't be the same one. But everybody that I've ever dealt with on this has got a firm number in mind. And we play around here, and we play with the zoning ordinance and tweak little things to try to cover up the fact that we have a firm number in mind and try to control it with other things. And we're complicating a lot of things going that way. Now, I've said it, and it ain't gonna happen, so I've said it.
Never say never.
And I think the PRE, had we had that earlier, would have taken hundreds off from the rolls, because every second homeowner probably wouldn't have qualified for a PRE.
It's been history in this town for many, many years. The people come here, buy a home, and rent it out to pay their taxes until they're ready to retire, and then come here and have a house to live in. And
True.
that isn't gonna happen anymore. I've got it right across the street from me now, and it's working for him as long as he has a short-term rental. But it isn't the way it worked for his dad.
yep. All right. Is there much else we can do with this right now?
Would you like us to notice a public hearing for the next meeting, or do you need to see it one more time before we notice a public hearing?
Yep, I would. All right, let's just do a straw poll vote on this. Who wants to see the amended ordinance before we do a public hearing announcement?
Okay.
Everybody?
We'll bring
There
it
you go.
back we'll bring it
One
back
more
at the next
time.
meeting, I hope.
All set?
All right, very good.
Mr. Chairman, may I be excused?
May.
It was a pleasure.
Thank you for staying.
Good to see everyone. Thank you.
Okay, new business, master plan goals.
our master plan goals and actions were edited by our team at the Southwest Michigan Planning Commission, Marcy and Becca, based on some feedback from staff as well as survey data and discussions at our previous meetings. My intent for this evening was not necessarily that we would hold a workshop, although, Mr. Chairman, if you'd like to do that, we can, but rather to assess whether or not we're on the right track and whether or not you all would like to schedule a workshop, or whether you feel comfortable accepting the document as is, knowing that we're on a timeline, and if we do need to schedule a workshop, that's fine, but I would say that needing to schedule 8 or 12 workshops to talk about master plan goals is probably more time than we have.
Well, what does everybody think about what has been submitted to date? Does it look on track?
I would like to see the whole marked up master plan. We don't really have that. And from what we have from this list, I've identified 2 items that were identified as being completed, but I think that's a bit overly optimistic. Items 2 and 3 on page 97 of the agenda packet relate to, the first one is existing height and lot coverage, the second one is management of short-term rental. And those are ongoing, those really haven't been completed, so I would like those reinserted back into the master plan under residential development and neighborhood character. If they do remain stricken, then I would like the master plan draft to show that they're stricken. These 2 items are not shown in marked up changes as being removed, unlike other changes that were removed.
Okay. Anything else?
So I would like to, in combination with the master plan, I would like the Edgewater coastal report brought back to accept so that it can be fully incorporated into this without any hiccups.
I think it was never staff intent to have the Planning Commission approve that plan. It was a technical study that was provided to the city for informational purposes. We were never planning to ask for a vote of acceptance from this body.
And I do see that some of those suggestions have been incorporated into the master plan.
Okay, I just didn't want any hiccups like with the special land use.
Anything else? For now? Okay, who's next? Larry?
Kelly, I have a question on page, I guess, page 99. Yes, at the bottom of page 99, there's a highlighted number 12. Refers to a coastal planning committee. Is that our subcommittee?
It is. Yes.
Okay, that is far beyond what that committee was set up to do. And I think that committee has enough important work. They should be concentrating on what they were set up to do rather than going to the extent of A, B, C, D, E, F, and G. I think D is the only thing that they really should be concentrating on. Maybe that should just be reworded to set up a committee to do the A, B, C, E, F, and G.
Yeah, I don't know where this one came from. Because all I did was set up an ad hoc committee.
It was, yeah, it has the word ad hoc in it.
Yeah.
And that's,
This is like a permanent kind of,
yeah, and
Change
much
committee.
broader scope than anything. I thought that I had taken on when I took the chairmanship of that ad hoc committee.
Thank you, Larry.
You have to be a full
So-
committee to get a coffee mug.
Some of
Ad
the-
hocs don't even get coffee mugs.
Some of that language to form a committee and take next steps was in that regional chapter, and so that's where that language is coming from.
Or is there grant money available if that happens?
Perhaps there is some grant money if, there is often grant money available for regional planning efforts.
I do recall in that coastal plan that they really wanted to incorporate the community into the discussion in order to have buy-in from the community, understand what they want. So I think that's where it's coming from.
Well, what our committee will do is have a proposal for this commission, and then there will be public hearings, and if, more than that, if we feel it's appropriate, but,
Well, you got an ad hoc committee that we formed for a specific purpose.
absolutely.
It's not open to a lot of other items. It was formed for one task and one task only. All right, what else? So we can get moving.
I think that the housing section or the residential development neighborhood character is really important, given the focus on housing for the future. And so it might be useful for us to spend a little bit more time going through those in a workshop format to really make sure that we have it tied down for the next 5 years, consistent with what the policies of the, where the policies of the city council are wanting us to go, and for just future development. So that would be my suggestion.
Hopefully the policies of the city council are related to this document.
Hopefully.
Yep.
We,
Hopefully. And along those same lines, that's why I would like to see the document in, marked up form, because I know one insertion included reference to short-term rentals, but I think that it wasn't really what I was expecting to see with regard to short-term rentals in neighborhoods. So that's why I would just like to see something, a whole document, to see how it all interrelates.
What was the timeline for receiving the full draft?
Originally, we planned to have the master plan completed by the end of the year. I know that we have missed that deadline. And so I don't remember off the top of my head at what point we were to receive a whole draft. I would have to look.
Okay.
Wouldn't we need the whole draft to have a public hearing?
Yes. We're not asking for a public hearing at this time.
No, I knew that, but
Okay.
I just wanted
Yes.
to make sure.
Absolutely. I do want to also mention, I know we haven't gone all the way around the table yet, but I do expect to have a public input open house. We've tentatively scheduled October 10th from 4:30 to 6:30 in this room for the public to come and offer input on housing and coastal resilience, so says the flyer. So Marcy and Becca will be planning some activities or maybe boards to vote on. I don't have all of the details fully available yet, but the 10th in this room would be an opportunity for the public to come as well.
What's the date?
October 10th. It's a Thursday.
And the time?
4:30 to 6:30.
Okay, because Parks Commission meets that day.
Okay. We may need to look at a different day then.
I went to the calendar.
Parks Commission would
That should be on
typically be
Tuesday.
7
Oh, wait,
o'clock,
I'm
so
sorry.
4:30 to
I
6:30
have-
would be okay, I think.
No, sorry, my fault. I had it on September. I forgot to advance it to October.
Okay.
So, no, that's clear.
Quite careful. Okay.
All right, so with what you submitted here, you're asking if that's sufficient, or whether we need to schedule a workshop to go over
goals and actions.
I don't know, everything looks fine to me. For what this document truly is. I don't need a workshop unless you guys do.
And Kelly, can those two items get reinserted into the goals?
If
that
the
I-
group agrees, yes.
So how do we, from the input from the public then, how does that get incorporated into the master plan?
So, unless you guys want to look at this as is before the public open house, right? We'll do a workshop, have the open house, then you do another workshop. Or we leave it as is, or with a couple additions, have the public open house, then we do a workshop.
Yes.
Yes, and I'm fine with that second alternative. No need to have two.
For those two items, though, I mean, I had asked the basis of their removal, and it wasn't clear exactly why those two items were removed. And I know that the residents are very concerned with existing height and lot coverage requirements and also management of short-term rental ordinances. And we are actively engaged in that, so I do not understand how they could be identified as completed.
And those two items were in the prior approved draft.
Yes, they have been stricken. Unfortunately, they don't show up in the track changes. They were completely removed.
Yeah, so put those back
We can
in.
put them back in.
Thank you.
Anything else? All right, so what I'm reading is, we're okay with what's here with the small put back in, and we have your workshop, or not the workshop, the open house. And then on the heels of that, we'll do a workshop, just in case there was some input. And do you have any idea how they're gonna take input? Are they gonna do like cards or like sticker, multiple choice kind of thing?
It will be
or-
something like that.
It's gotta be
Yes.
easy and something easy to
Yes.
categorize or put in a spreadsheet
Right,
that we can distill down without spending
yes,
2 months doing it.
yes.
Okay. Very good.
Post-it notes.
All right. Anything else regarding item 10? No? All right.
No.
Item 11, commission members, staff comments.
I wanted to mention that we have a new assistant city manager, Michael Landis. I think most of you had a chance to meet him before the meeting, so welcome. Sure, come say hello.
Good evening, everyone, Chair, Board. I appreciate being here, and I cannot wait to be an active member of this community. I've come from the other side of the state, as it might be. I hail from a small community of Gibraltar, where I was manager for just under 3 years, and I'm excited to be here in South Haven now in the assistant manager role. So I look forward to working with everyone, and that is about it.
Where are you from?
Gibraltar, Michigan.
Oh, okay. Very good. All right, thank you for introducing yourself, and we look forward to working with you.
Thank you. That's all from me tonight.
Okay, where'd we start last time? We'll go to my left, start with Clark.
Good work, staff. No comments.
Good learning experience.
I don't actually have any comments, but welcome, Michael. There you go.
Yeah, I'll second that. Welcome, Michael. I'm sure Kelly will be glad to have your help. I sent an email this week to Mike Campbell because I thought Mike had done a lot of research that was valuable and interesting and relevant. And I know we all do some of that, but when it gets shared, it's helpful. So way to go, Mike. I'm going to be attending the planning meeting in Grand Rapids, September 25 to 27. So thanks to Kelly for making that happen. And then there was an interesting news item on a TV news tonight, in fact, an initiative in Kalamazoo, and they look like tiny houses, but they refer to them as pods. And I think they were intended to address homelessness. But guess what happened? The old NIMBY thing, not in my backyard, and the whole thing has been basically scratched. The developer has walked away from it because nobody seems to want it in their backyard. So that's an ongoing problem, but it was relevant to our goal for more affordable / attainable housing, but just shows again how difficult that is to achieve, so.
Thank you, Bob, for your comments. Welcome, Michael. Thank you, staff. I'm done.
Welcome, Michael, and thank you, staff, also, for everything for tonight, and thanks to Attorney Bloom for coming. On Tuesday, I attended a regional housing partnership meeting. So the state has a program that's been going for a while, and so Van Buren, Cass, Berrien, several counties are identified as Region J. And Mayor Brown and I attended, and we addressed the very issues about what hurdles are we facing, what are some of the shortfalls, trying to have an overall view for the county and the Southwest region. So I'm excited for that, and I'll be getting more engaged in that. And I am just looking forward to working on our ordinances to help our community move forward.
I would like to thank the city for really managing the Labor Day crowds. It was so energizing in town. I don't think I've seen so many people in so many different areas of our town. In our neighborhoods, of course, the craft fair down there, and then the salute for the veterans. The town was just buzzing, and I know that doesn't happen by itself, that it takes a great deal of planning and also volunteers in our communities that have made all of this possible too. So thank you to the volunteers and thank you to the city.
Nothing to add.
Okay. Oh, all right. So we have a bunch of things coming up, right? So the ad hoc committee, the workshop, open house.
Yes.
And so I might just want to do a preliminary draft calendar, send out to all of us so we can put that in our planners and make sure my concern is that we have quorum for all these, because otherwise why schedule them?
That'll just be my 6th calendar to keep an eye on.
And we're coming up to that time of year where people start disappearing for the winter. All right. Now, how long do you think you'll be with us, Megan?
Maybe for October, I'm not sure.
Yes, we are hoping to have a new Luke, who will be nothing like Luke, start at the end of the month. And we'll be able to say more about that in the coming weeks. So, but this person will be new, and I don't know how comfortable yet taking minutes right out of the gate, so.
Okay.
Might be stuck with Megan.
But if so, just remember that when you guys are making motions, you know, if you deviate from staff report, need to be clear, concise, and slow down so they can get it in case I ask for it to be repeated. Because sometimes they get confusing, the on-the-fly amendments, motions, so. All right, that's it. Let's get out of here. I'll entertain a motion to adjourn.
I'll make a motion to adjourn.
Support.
It's been moved and supported. Any other discussion? All in favor, say aye.
Aye.
All opposed? Motion carries. Meeting is adjourned.
Kel-